A very good evening to everyone present here. Please be seated. I think it was a wonderful session with different perspectives being provided. Now the house is open for everybody on discussions on way forward. And the session is moderated by Ms. Arlene, Manoharan and Nimisha Srivastava. Ms. Manoharan is the co-director, Restorative Practices at Enfold Trust. She graduated from TIS, Mumbai, and brings 35 years of experience as a social worker in the field of child protection. She worked with children in street situations through various NGOs and subsequently at the Center for Child and the Law at National Law School, Bangalore, where she was a fellow heading the Juvenile Justice Program and later as center coordinator contributing to socio-legal research, training, teaching, publication, and towards effective implementation and reform of policies and laws governing children. She is also appointed to various expert committees such as rules drafting and expert committees under the Juvenile Justice Act, and continues to engage in casework, training and teaching while serving as a restorative justice practitioner and child safeguard expert. And our next moderator is Ms. Srivastava. She's the Executive Director of Counsel to Secure Justice, an organization working on access to child survivors of sexual abuse, children in conflict with law and child protection, system strengthening with a focus on using restorative approaches. She has 15 years of experience in advocacy, capacity building, justice systems, rights-based law implementation, public policy, development research, stakeholder engagement, and mass communication across juvenile justice, child protection, gender-based violence, and restorative justice. She has worked with UNICEF, local NGO profits, as well as central and state governments in India. She has studied international human rights law at the University of Oxford as a Commonwealth scholar. So now we'll begin our session. Thank you.
Thank you so much. Good evening, everyone, and we've reached the final session of our very, very rich consultative process over the past 2 days. It's really been an intellectual feast, and it's been given so much of food for thought. Before I start, I'd like to make a bridge between the last session and this session. I think for the past 1.5 days, we've really been highlighting how this law is really so, it's actually violating the rights of children in many ways. Some positive news, because I think from the earlier moderator, Inakshi, you said that nobody is doing SR-HR work and, the education system, the curriculum, it's not there, comprehensive sexuality education. Just want to say some positive news that in Karnataka, the government of Karnataka has formally accepted curriculum developed by Enfold along with others, and it's now part of government curriculum. So it's a great place to say that at least one state in this country, the government has created space for this to be introduced into the school curriculum. Hope it's a precedent for more. So some positive news to get into our last session today. And before I start, another point, I think this is, I was just telling, many of us in the room have been here 11 years, 12 years ago, being part of efforts when the Juvenile Justice Bill had come out. And for me, it's really a sense of deja vu, because most of the issues are exactly the same. It's now being fleshed out with the lived realities of children, of lawyers, of social workers, JGB members, and others who've been really trying to see how the objects of this act can be really played out in terms of the way we implement this act. And there was some talk about challenging the constitutionality of this act. From what I understand and what I'm hoping for is that, at least in this room, I think there's a sense of shared understanding that yes, the statute has to be challenged, but may I really appeal for, what should I say, a sense of solidarity, a sense of patience, and a sense of standing together to really work with each other to identify cases that will really be successful. Work with each other, not, because we need to stand for together on this, and we need to have a commitment to strategic litigation. Because if you're not strategic, the consequences can be absolutely devastating. And we are hoping that whenever the time is ripe, when we have adequate evidence, when we've collected enough voices of children that are not being heard adequately, when the voices of children and those stories we can collect and make it part of that litigation, where together we can ensure that it's really meeting that objective of ensuring that children's right to access to justice and to have this beautiful preamble really played out in their lives. So if we can achieve that together by being strategic, by being a child rights community that listens, and yes, we dissent and we disagree, but we agree to disagree, but then we keep the best interests of the child at the heart of that decision as to when and which case and who and why are we doing this litigation. So that's just a little appeal that I slipped in, and we're going to go into our last session. So Nimisha.
Thanks so much, Arlene. And I think that's a wonderful note to start our open house on. And exactly as you said, there does seem to be a shared intention, shared concern in this room, which is very, very heartening to hear about, to talk about. And I think there is a lot of shade thrown about, like intellectuals coming together in conferences. But I think conversation is important. Us coming together in one space and talking about these things and recognizing how we are not alone in feeling what we are feeling, I think it's really important. So I hope that all of us go back with that. Along with that, what we would like to request you right now for this open house is that we all take a few minutes to reflect on the conversations that have happened, on the work that we have all been doing in different capacities across the country. And, think about where do we go from here. We all know that there are multiple challenges. There are actually, even though we don't really talk about it, but actually there are things that are being done better, as the hopeful note from Arlene also indicated. So let us think about what we can do when we go back. What are the things that we do individually, collectively, both. At the same time, I acknowledge, I think Bharti was raising this concern to me that we don't want to sort of come up with small little solutions that make this entire problematic provision acceptable. So what my suggestion would be is, when we are doing this reflection and thinking, let us think about it in terms of how we develop, something we in the NGO world call a log frame, that we think about short term, what are we going to start doing right now? Medium term, what can we do over the course of next 6 months, next 1 year? Like, say, for example, evidence building. And what is the long term objective? One of it is the strategic litigation for that. So 3 things: the short term, the medium term, the long term. We can all take a few minutes to think about it, and then we will open the house for sharing of views on this. We will also be sharing a link to a Google form. So I would request everyone to please write this down so that you can fill it up in the form, and we have all of these commitments with us, which can be a part of the report. So we are informed by really a roadmap on the way forward that we can all go back with.
Nimisha, can I just add to your suggestion? One is medium term and long term, but maybe there's another framework that we could use, which the UNCRC provides for us as duty bearers. Is there some way in which we can make a more sincere effort to respect children's rights, to protect children's rights, and to fulfill children's rights? So the 3: respect, protect, and fulfill, those 3 dimensions. And if we also have to stand up, perhaps in a gentle way and sometimes in a firm way, against others who are our colleagues within the same system, to say, hey, this is really not happening. So nudging each other. So one, what we can do to respect, protect, and fulfill, and what we can do to appeal to other duty bearers in our circle of influence, and maybe appealing to higher authorities as well, to urge for respect, protect, and fulfill children's rights. So it's just another framework for those of us who are in the rights framework. Yeah. So what we will do is we'll take people who have suggestions, and anyway, you will have your Google form, which you can write it in a little bit more detail when you're a little bit more clear in your thoughts plus. But yeah, so I have Bipasha. Yeah.
I would like to thank all of you at the end of this session that he has given me an opportunity to be a part of this August gathering. And like Maruk had told today, till this provision gets repealed, till it gets repealed, I am now continuing. Okay. The first thing that I would like to say, like what Nimisha was telling, that working out measures or tips that in this 2 days consultation, we got a lot of tips as to how to empower the JGB members and the principal magistrate and the stakeholders to stop the transfer to the children's court. Lot of things we have got in our plate now. We know that we can do a compilation of all those thoughts and practically how we can stop it. That's one. The two is, during this process of this this process of preliminary assessment, I have seen children committing suicide. In the first hand, a child had committed suicide when repeatedly the bail hearing was rejected by the children's court. So my request is, we are getting support persons for the victims of POXO cases. And today, Kalpana was saying that even the POXO cases, the boy, the CACL should also get a support person. Similarly, I'm talking about not support person maybe, but the case workers in the CCI or the social worker members, when the child does not get bail repeatedly, staying in a CCI, being in the children's court, the child should get support. Otherwise, these suicides will continue. Okay. The other thing that I wanted to say is, we are talking about database. So in West Bengal, we had missing the track the missing child portal, and that has become Mission Vatsalya portal. That portal collectively collects all the data of the number of types of offences. In that, I would like to suggest that we could add the preliminary assessment portion also. Then what happens? We have all data in one place. At least we would have that, how many cases have been transferred to the children's court. That the JGB can do while they are filling it up. The other suggestion that this is not a suggestion, it's a question. We are getting 3 months for preliminary assessment to complete. If that 3 months time is getting over, where has it been written in the act that they will get an extension? Nowhere has it been mentioned. So if they do not get an extension, can the child on that plea be retained back because the 3 months is over? So this is just few of them, and rest I'm going to write in the Google form. Thank you.
Thank you. So I see this as also a legal question. So does anyone who wants to respond to this proposal or any other proposals, that on the condition of the completion of 3 months that a child can be retained? So there can be a little discussion as well. Yeah. Anybody else would like to either add or respond? I see Gitanjali. Yeah. Can a mic?
Hello. I think it might probably be just a point in addition to what ma'am just shared right now. But I think my observation from this 2 day, it's rather very sad that, mental health is so critical. And mental health as envisaged within the JJ Act was for rehabilitative purpose. But how have we arrived at this stage where mental health has been weaponized to further a very oppressive structure for children in conflict with law? And already I think it's so sad how, a lot of professionals are sort of putting so much. Mental health already doesn't exist for children in conflict with law. The service is extremely lacking in so many spaces. And yet the thoda sa existing services has been used for some form of assessment, which I don't know is resulting to what. And so I feel an overall discussion need to take place कि हम mental health को JJ system के अंदर किस तरह से देख रहे हैं, किसके लिए देख रहे हैं, and what are children actually getting out of all this thing which has been happening. And we need to engage mental health professional in these discussion more and more. Very, very heartening to see a few mental health, professionals who were very out and open about their ideas. But when I was actually studying, I studied about anti-oppressive, structures of various kind of, such intervention. And here, day in and day out, one is just hearing कि जो भी मेंटल हेल्थ के सर्विसेज थेरेप्यूटिक रिहेबिलिटेटिव इंटरवेंशन में जाना चाहिए वो कहीं और जा रहा है. And I think that is one serious area of consideration that we need to look into.
Could I? Thank you so much. I think that's a fantastic idea. I'll just come to you, Sanuti. Could I just add a little bit to that? I think it is very, very important to have these conversations with mental health professionals. What I would also like to add to that as a suggestion is, let us not wait for state level or national level consultations and conferences to happen. It is very, very important even within districts, or even at a more granular level than that, to come together and have that conversation with counselors of CCIs and DCPUs. Get them together and understand from them what are their challenges, what are they thinking about mental health under the juvenile justice system. So just to add a little bit to that. So
And I would like to add
Yeah.
also, thank you for that, Nimisha. Just like to highlight, just like the whole JJ Act, which was meant to be a rehabilitative act, is now being weaponized in one sense. I totally agree with you. May I also just add, not just about mental health and PA, but also the role of counselors and what is written in their counseling reports for any child in conflict with law. What is the role of the counselor vis-a-vis a child in conflict with law, and should those reports go in to assess guilt, to help in the assessing of guilt, rather than in really enabling rehab? So just wanting to add that to that. Thank you so much.
Sanuti, and then Shubham and Aarti. Then I'll, like three, and then other people.
I was just going to add to whatever has been discussed right now, specifically with mental health. This has happened historically across the world, where psychiatric institutions and psychological services have been used by the state and by law to concretize and create distill some fictional certainty out of an ultra gray area. This has happened time and time and again. The fact that it has space in the JJ Act right now is not only dangerous, it's scary, but I mean, I don't know how many other practitioners here have dealt with situations where a parent has come and said, just make our child better, just do something with it. It feels like the law is asking that again of mental health professionals, saying, yeah, just figure it out. Tell us what this person can do, what this person cannot do. So I feel like mental health professionals need to understand that they are being used. You need to know that you are being misused in order to create a fictional certainty when it's not possible to do.
I think Aarti had raised her hand.
I had
and
also-
then
I just
Shubha.
want to-
Yeah, just one second. I'll take Aarti and then I'll come to you.
No, let her continue
before
the
you?
mental health
Okay.
point. I think it's
Sure, sure.
So I'll just respond to the concern around mental health. Let's just move out of the court for a moment. हमें सिर में दर्द होती है, या हमारा हाथ टूटता है, या हम गिरते हैं और हमें चोट लगती है, तुरंत हम डॉक्टर के पास जाते हैं या किसी एक्सपर्ट को कंसल्ट करते हैं. शरीर की एक एक हड्डी के टूटने का इंतजार नहीं करते हैं. मेंटल हेल्थ भी ऐसा ही है, और स्पेशली जब ये मेंटल हेल्थ का इशू कोर्ट में घुसता है, तो वी कम फ्रॉम नोइंग नथिंग, वी कम फ्रॉम ट्रस्टिंग नथिंग, and we then eventually go towards doing nothing for the child. So in some cases where we see in the process of preliminary assessment, where I ask the school to tell me what is the nature of the child, what is your observation, when I ask the teachers, बच्चा आपके सामने कैसा था, आप क्लास में पढ़ाते थे तो क्या बच्चा बोर्ड की तरफ देखता था, क्या बच्चा आपकी तरफ कॉन्सेंट्रेट करता था, जो आप होमवर्क देते थे क्या वो कर पाता था, तो वो बोलते हैं कि वो बहुत शरारती था. तो एक मामूली शरारत को अगर किसी काउंसलर को उसी पॉइंट पे दिखा दिया जाता, एक डेवलपमेंटल प्रोसेस समझ के दिखा दिया जाता, जैसा मैम ने पॉइंट आउट करा, एक साइको सोशल माइलस्टोन न अचीव करने के प्रोसेस की तरह से दिखा दिया जाता, एक कंसल्टेशन से शायद वो बच्चा सीएनसीपी की कैटेगरी में भी नहीं रहता, सीआईसीएल तो बहुत दूर की बात है. तो मेंटल हेल्थ के आसपास, बिकॉज आई ऑल्सो एडवोकेट फॉर mental health of children in classrooms, and I also do a lot of awareness programs on how to identify
Could I request
problems
so,
in the
because we
classrooms.
need to really get in the
Recommendations.
action
No,
points.
I think it's
Yeah.
a serious concern, because
Yeah.
from the 2 days that I've been observing all the speakers put in their insights,
Yeah.
there is a lot of you can say ambiguity around what a psychologist really does with the PA. So my only submission over here is the only way to get rid of this gap between you and me is I learn a little bit about the law and you learn learn a little bit about the mental health processes, and that's how we can
Yeah.
maybe work together for the child. Thank you.
Absolutely.
Can I also request जो JJB के magistrates हैं और members हैं, खास करके जो खुद इन processes के साथ deal कर रहे हैं, legal services authorities से जो लोग हैं, वो लोग भी please share करें. I understand कि ये हम लोगों का बहुत ही एक safe space है, यहाँ पे हम लोग already काफी सारी बातें बोल चुके हैं, तो इसका कहीं ऐसा नहीं है कि बाहर वो जाएगा. तो I would request कि जितना हम लोगों ने कुछ जैसे कि मैम ने काफी अच्छे से शेयर किया कल कि क्या जेजेबी का क्या पर्सपेक्टिव होता है, तो आप लोग भी प्लीज शेयर करिए हमारे साथ, क्योंकि हम लोग सब साथ में ये एज आई सेड बातें करेंगे और इसके सॉल्यूशंस निकालेंगे तो बहुत अच्छा होगा.
I just want to say that I do not think, and I'm very concerned about this, I do not think that the preliminary assessment that is being conducted is being done to address the mental health of the child
Correct.
in conflict with law.
Yeah.
So when we are using the word mental health here, we are not addressing the mental health of the child. At no point of time should there be any confusion that, because everyone seems to be saying mental health. It is not mental health of the child that you are addressing. You are generating what is believed to be a report that is required to make a particular sort of assessment by a court of what has to be done with this child. Where in the mental, which PA report are we speaking of that is saying that the mental health of this child needs to be addressed?
Yeah, it's not a therapeutic.
So it is not at no point of time is a PA report a therapeutic intervention at all. It is a data, if at all I want to call it anything, it is a data generating exercise into the depths of the mind of this child. That is the best way to capture it.
Yeah, I think Aarti, what was being said and what I understood from these past 2 days is that the psychosocial experts, whoever they may be, need to recognize what is the purpose and the implications of the PA. That clarity is not there. Yeah. No, I think that is what was discussed.
Vineet has his hand raised for a bit. Yeah, Vineet. हाँ sir, आपका तो sir आपका लेंगे फिर Vineet and I think then Krishna. Yeah.
Okay. As a body, can we recommend or advocate for making better selection of JJB and CWS members?
Better selection.
That is, people who are experienced in child related work, especially in psychology, psychiatry, etc. Because selection of JJB and CWS members are not, no guidelines are followed. Many advocates have been appointed. That's a great concern.
Thank you so much.
Secondly, one more, whether better speedy justice. For example, my experience of dealing with child marriage cases, etc. 13 to 14 years are taken for certain cases. So speedy justice for journalists goes, but the judges may be more affirmative in protecting children's rights.
Right.
This to come.
Vineet, thank you so much, sir. Thank you.
Thank you. So I just have one suggestion for way forward for the organizers of this consultation, which is that if we could have the contact details of all the participants here shared publicly to foster, not publicly, but within everyone who is here to foster collaboration for later.
Sure.
Speaking of how I see my role going forward and what I have learned from here, since I'm a journalist, I am what I plan to do is to do stories on the kind of things I've learned here, and clearly the way the juvenile justice system works, there's hardly any like it needs sunlight. We need for the society to understand what are the concerns here, some of the concerns which we've discussed. So I hopefully will reach out to a lot of the people here in the room. I've already taken your the contact details of some of them. I would urge that especially some of the fine folks here from who are working with the government, because CSOs are usually, as I said yesterday, are much more accessible for journalists, but for people who are working from within the JJBs and within this within the judiciary and within the government, please feel free to reach out and talk about like your experiences, and if you have any data and stories, and of course confidentiality and all those things would be taken care of.
Thank you. Thank you for saying that. Just to remind everyone once again, no, I think Krishna and then ma'am. Just to remind, we are talking about, before some of the people came in, short-term goal, medium-term goal, long-term goal. We are focusing on the way forward now, not so much reflection. Krishna, please. Thank you. Gitanjali ma'am, and then we can.
So I have a few points to make. So going from what Aarti was just saying, so I also want to reflect on that. So last 2 days we have been talking about mental health again. So as it was pointed out, when we are talking about PA, it is just a report we are talking about, which is a mental capacity which is to be judged. It is not that the they have to do some counseling or they have to prepare a mental health report. Secondly, we are stressing so much about the mental health report or the psychosocial report, but that is only one aspect. We must remember that it is only one aspect of the PA that is to be done by the JJBs, and the JJBs also have to consider the other factors. It is not that you can base your assessment and your order simply on the mental assessment or whatever assessment is coming to you. The members or the principal magistrate, the JJBs, collectively have to apply their mind to even that report as well as the other factors, and then take a collective decision what is to be taken. So going forward from there, I will reiterate what I said in my session, that I think short term we have to have capacity building, we have to have more training programs, and also training programs where probably we need some modules. Maybe NJ can take it up, like, some concerted modules which will focus on all the different stakeholders and specifying what is exactly required from them. We can't just have a random training program, like, on the JJ Act, talk about the provisions of the JJ Act, but every stakeholder must understand their role at the end of those training programs and how they are about to go about, discharging their duties under the JJ Act, so that we are able to achieve the objectives. At a medium or a longer level, so we have been, when the Act came 2015, all of us thought, what is this provision which has come in, which we essentially, perhaps is violative of the rights of the children. Today we have been talking about it. I think 10 years down the line also we'll still be talking about it unless we try to address it. So what do we do about it? We have been talking about data collection. So maybe we need more concrete data on the PA assessments. How many are such cases where, the children have been transferred to adult courts? And if they have been transferred, what is the percentage of cases where the orders have been set aside? I think that is material where the higher courts have found that the assessments are incorrect and they have remanded the matters back, or they have, just set aside and proceeded with the matter further, because that will actually tell us what are the shortcomings in the assessments which are being done at present. Secondly, we can also utilize that to then, take up the case that maybe on a judicial level before the superior courts, we need to perhaps argue for repeal or whatever, setting aside this, declaring it as unconstitutional. We've all been talking about violation of right to equality, Article 14, 19, and Article 21, all those. So we have to use that. And maybe at the legislative level, we also need to, maybe have some resolution from this house or whatever, but we also need to take up not only this issue of PA, but also the issue of, that age of consent we were talking about. I'm not very sure that I really think that, we need to lower the age of consent. But what we really need to do is build in certain provisions by which those, the consensual relationships are excluded. At what level are we going to give that authority? Whether it's going to be the courts, or is it the police, or is it some other person who's going to decide that this case should be outside the criminal justice system? So we need to have those safeguards, and those are some, I think, what we need to do at the legislative level. Thank you.
Thank you, ma'am. Thank you.
Okay,
Yes,
hi.
please.
I have 3 points to make. Number one, I personally think we've taken the privacy and non-disclosure a little bit too far. We're talking about privacy and non-disclosure vis-a-vis the child. And we've gone as far as negating accountability and research into juvenile justice. And that's something we need to qualify. That's the first thing. Second is what I'm seeming to understand from the House and the discussion is it's largely a one-way street when we're talking communication with the child. So we have forgotten to include him as him or her as one of the important stakeholders in the process. So we need to have better participation of the child involved. And that is something that we are missing right now. So we need to have better due process standards applied to juvenile justice. It's not enough to be paternalistic and to say that we have the welfare and best interests at heart. In this factor, we also have to understand that there is a concept of evolving capacities. A child of 8 and a child of 16 are extremely different. So we cannot equate and put them in the same basket. So we need to also involve them depending on their level of understanding, their maturity and autonomy. And the third aspect, I would say that we are talking in the last session about consensual cases. And we need to be very aware about the fact of the social realities. Number one, that there are different practices across the country, north, south, tribal, non-tribal, urban, non-urban. There are different factors we need to consider in mind when we're talking about consent. And there's an important factor we need to consider if we bring in a provision to deal with consensual cases differently, the potential of misuse, the way we talk about hostile witnesses, the consent could be something that is manufactured ex post facto. And it could be something used to compromise the case. It could be money, it could be pressure.
Reflection, no, please,
so that
please.
would be
So
something we need to be
actions, yeah.
careful if you're
And
bringing
we
a
need
change.
to have,
Thank you.
Yeah, thank you. Nainika and then Emidio and again, ma'am. Ma'am, can I get her to go first, please? Ma'am, आप पहले, फिर Nainika, फिर Emidio.
Regarding the data collection thing which we were talking about, so according to me, it has to be done on daily basis. Otherwise, if you ask for the data after an year, that please provide us the data. Suppose we are being asked to give our data. So you have to collect that data because we are not being maintaining that data. So it will never be proper. So if we want the perfect data, according to me, what we can do is we can have a central website in Supreme Court and then adding every state. See, the links can be added and thereon in every state, every district. So that can be bifurcated accordingly, and we want somebody to feed that data on a daily basis so that it is always updated and you can see that data any day and it is accessible to.
आपके JJB में वो data entry operator है वो.
We have the data entry operator. We have a internal CIS system also, but it does not bifurcate this thing into preliminary assessment. So we can add those heads.
Maybe can I just add to that? Maybe the juvenile justice committees the secretariats
that
of
is
these
what I'm
committees
saying,
have
so.
to be linked to.
Yeah. So all these committees can be linked into one central website and you can access that data from anywhere. So that will be possible if we are feeding that data on a daily basis. So that is possible. And also, I want to add one more thing, that we were talking about eradication of the details of those children which are there with the police stations and everywhere. So this is a very serious problem. I have raised that problem earlier also. So what they have told me is from their central system, suppose there's a case where adult is involved and a child is involved. So there's no segregation at their point when the FIR is being lodged. So when you want to eradicate a part of it, it is not possible for them technically. So we have written that and they promised that they'll work upon it so that we can just remove the part of it or maybe the name of the child or something like that. So they're working on that. So we need that agency also to be involved so that we can work upon that. Otherwise, it is not practically possible. That like I send the entire month's data to the concerned police stations, but they are not technically able to do it. So there's a problem at their end also. So we need people from there and to take responsibility of that. So these are my two suggestions.
We
Thank
have
you.
9 minutes exactly. We are going to try and take 5-6 inputs at least. Nayanika, video, and then I'll have to go to Bharti. I'm sorry. We'll send a form for sure. Yeah.
Okay, I'm not going to take very long. I actually want on what ma'am said about the data collection. We could basically have like a data template that the JJC Secretariat could come up with, or if not them, the CSO organizations can help come up with a data template. Secondly, what Geeta ma'am was also saying, I wanted to add to that, that maybe with the training, we also need several more intersectional dialogues. Like while the training that happens, there should be mental health experts who interact and engage with JJP officials, with other officials within the system. Thirdly, I actually don't know what the reality is, so this could go a little wrong. But I wanted to understand whether in the JJ system we can move a little bit towards standard operating protocols, which could.
There is no dearth of standard operating protocols.
Right.
There are too many of them.
Too many of them.
Emilio, please.
Yes.
Yeah.
Ma'am, one JJ Act and various processes across states and within state, different JJBs follow different processes, different interventions. Can we look at identifying certain checks and balances? For example, what can be done to safeguard the CCL? When is the PA report supposed to be called? After the charge sheet, before the charge sheet? What is the process involved when the child needs to be sent? When is the counselor to be called in? Like how we have for CNCP in POXO cases support person, can we look at somebody also for a child in conflict?
A support person for a child in conflict with law. Bharti and then Swagata.
And last is, are we sending this report to the Supreme Court JJC for?
We will, I think. Yeah, we will.
I think we need to send this suggestion.
Yes.
Okay, I just have a few quick things. Even after 2 days of meeting, there are still issues around maturity of the child. So how mature is the quote-unquote mature child remains a question even today. At that time, we had not found Indian studies to really relate to and use to build our arguments. I think it's time we start investing in that kind of research. And it cannot only be NIMHANS. So can we have tie-ups with some universities and explore these issues? That's one. The second is that when we talk of training and sensitization, one thing that hasn't happened in all these years is judicial magistrates, principal magistrates and social worker members sitting together in trainings. And we've, that's really needed desperately. Can I just respond to that? It has been done at Center for Child in the Law, I think about 11, 12 years ago. First, the social work members were trained first, all of them. And they were given all the materials and you learn the provisions. And when the JJP magistrates come, you may know a little bit more. So it was done, then they came together. So there are, I'm sure in other states it was done, but just to reinforce that.
Yeah, I mean, it isn't an institutionalized practice that
Correct. It should be institutionalized.
Together.
Absolutely.
Right. And
It is happening. Swagata.
Yeah.
You have,
Okay.
Okay.
I think I've slipped from my head now. But anyway, so this and something which we should not do, and something that Aarti and I were discussing, that let's learn to go slow and not jump to court. We think solutions lie with our Supreme Court. And if we plan to get into litigation, can we, as our allegiance to the cause and as our commitment to the cause, today decide that we will have discussions first before we jump to court? Thank you.
So jump to court, you mean for strategic litigation,
For strategic
not individual cases,
For strategic
right? For
litigation.
strategic litigation.
I had already made,
Swagata.
I have a few practical suggestions. There are 15 states here. Oh, sorry. Don't have time. Who's adding? Yeah.
5 seconds.
Yes.
If at all anyone is planning a court intervention and you feel you really need to do it, can it please be done, tested at a high court before we go to the Supreme Court? Please, I am begging, because it will be, I cannot say this. You lose there and that's it.
Exactly.
But if you lose in a high court, you still have you've left something left, you have something left in the tank, you may want to push it at another level. But please, can we just keep this in mind as regards Supreme Court intervention?
Thank you, Arti. Swagata.
Yeah, 15 states here. I think there's a lot of things that we have discussed. Can we at least have webinars when we go back? I don't know how practical it will be to have physical meetings, but there are SLSAs, there are judicial academies, and we can write to the different states that are represented here. At least have a webinar and we can support. There are many organizations there who will be happy to support, bring some of the resource persons that we had here online to have similar conversations in our respective states. Second, I think for the data template, it's very important to make it a consultative exercise. I know UNICEF and JJC has come up with a template, and there are aspects of it that need tweaking and that need conversation with multiple stakeholders, including those who do data analysis. It's not enough to know the system, you also have to know how the data needs to be interpreted. So I think the recommendation can go to the JJC that in the creation of this template, please try and include representatives that are across different sectors. Lastly, to say that Enfold has undertaken a study. It's a bit dated. It started in 2022. We have data of 625 PA orders from 3 states, as well as 113 interviews. And we're hoping to have it published this year. And I think that can again give us a lot more, articulate everything that came up here, but in print.
Ma'am, just a little suggestion from my experience. Ma'am, the psychosocial report which is made in heinous cases for the child, if we can do that at the very first stage when the child is produced, like in the remand court, like for bail, when the social investigation report is prepared, SIR for that is compulsory for deciding a bail. If the psychosocial report is also prepared during that time, so before the child comes in, I mean, just a little
it is treated by many JJBs as compulsory.
We haven't practiced
but
it,
it is not. The law doesn't say that it is compulsory.
It's not compulsory, but before the child comes in contact with other elements of the society and manipulate it,
right?
At least we'll have that first-hand information right
so you
after
mean the SIR should come in before the other
not the
documentation?
SIR, I'm talking about the psychosocial report.
The PA report?
Yes. Not the PA report. I'm
All right.
talking about the
so that is one
mental-
suggestion. Ma'am, please put this in more detail in your form. We will be sending a Google form link to everyone. And there will be a report which will include recommendations from this gathering. Thank you so very much, everyone, for participating so full-heartedly. This was a wonderful, wonderful experience.
Thank you.
Over to...
Thank you.